kind indulgence. My lord, in regard to item 6, my lord, a little bit of accommodation, if your lordship can take it as last item, or in between, my lord, when I'm free, I'll be.
Okay.
Obliged. I think at 2, my lord, your lordship will be busy in DB.
DB, and if DB permits, then we may come back if list is not completed.
That is uncertain, my
Ah,
lord. So
uncertain.
in between, my lord, I will just try. Obliged.
May I please the lordship? I beg to mention item number 22 and 23. I have taken the consent from other side. Kindly for accommodate for today, my lord. Next week, my lord. Twenty-two and 23.
Okay. You are for petitioner.
In one case, we are for the petitioner and in one case, we are for the respondents.
Okay.
Private
On
respondent.
the prayer of item 22 लिखले हो. You are in item 22 petitioner.
Item 22 respondent
Okay. Item 20 लिखले हो.
and 23 I am
The
petitioner.
prayer of the respondent, council, matter stands adjourned and listed and be listed
Next week, my lord.
after a week.
Yes.
Criminal petition 23 लिखिबो. But list this matter along with criminal petition. प्रथम तो लिखि दिबे खाली 1308. List this matter along with criminal petition 176 2024 जितु हुजेना का दिया either एटुट নহলে हेटुट. ठीक আছে. Yes, next.
May it please your lordship. Lordship, I beg to mention criminal petition number 510/24. And your lordship, this matter may be taken up 24 Friday for the admission stage.
Why? What is the urgency?
Because your lordship, LCR already has come, your lordship. Kindly, lordship.
It's criminal petition assailing what? What is the subject matter of this criminal petition?
Actually, your lordship, this subject matter is here, your lordship. The petitioner is the informant in this case, and she has sending
Is
the
it
trial.
punishment or criminal petition revision against conviction? What is this?
Your lordship.
What have you challenged in this petition?
Yes, lordship. The IO has sending to informant with the accused person to trial, your lordship. In a search
Okay,
of-
Monday.
Lordship, kindly, your lordship.
Monday,
Friday.
next Monday, 27. Yes.
And lordship, one another matter, BF 580/24. This matter is also now hearing stage. Kindly matter may be taken up.
BA hearing, no date fixed.
No date fixed.
Generally, BA date is fixed. See, look into this. Bail hearing, no date fixed.
No, lordship, no date fixed.
Huh? Bail
Passover
hearing.
matter.
Huh?
Passover matter.
Look into the order and see. Huh?
No, lordship, no date fixed. This is the mentioning by my junior date for Passover this matter.
Okay.
The last
Okay.
date.
Okay. If no
Monday.
date is fixed,
Both
then
on
only. Huh?
Monday.
If no date is fixed, then only. Yes. Yes,
Both
Mr.
on
Datta.
Monday, your lordship.
Bail we can give you on Friday also, even tomorrow also, no problem. Friday. Friday.
Much obliged, lord.
Yes, Mr. Datta.
I beg to mention for listing of your bail application lord, tomorrow. Lordship.
No, son.
Motion, lordship. Lordship, I beg to mention for listing of your anticipated bail application tomorrow. Lordship.
Motion. Pertaining to this bench only.
Below 7 years.
For listing criminal petition, lordship, tomorrow, lordship. Connected a criminal petition already fixed tomorrow, lordship.
Motion BA.
Mr. Bhattakur, 20 years young boy went to a
Yes.
showroom.
Yes.
He had stolen 3-4 items. How many days?
Since 1/5 minutes.
1/5 he was.
When were you arrested?
20 days, your lordship.
When arrested? When?
1/5/2020.
This is an application under Hoigol. It is alleged in the affair that the petitioner has stolen one helmet, one jacket, a pair of boots, a pair of sunglasses, 2 numbers of t-shirts, 1 hand gloves, and 1 wallet set from the showroom of the informant, bike showroom of the informant. Full stop. The stolen item has already been recovered. Full stop. The petitioner has been in custody since
1/5/2020.
2010. Considering the above, more particularly that the petitioner has been thoroughly interrogated, the stolen items has been recovered, disposed of the view that no further custodial interrogation is required. It is also apparent it is also apparent that CCTV from the record that CCTV footage has also been seized by the police. Considering so and so. This
CGM Kamrup.
to the CGM Kamrup,
Kamrup Metro.
20,000.
All right.
May I please your lordship?
CD interim.
Yes.
Within 10 days appear.
Obliged, my lord.
Ganguly, yeah, A. Ganguly. And what happened?
No, 20 June.
I am also appearing, my lord, from on BC.
Mr. Singh's name may also come in.
Huh?
I am appearing, my lord.
Yes, I am
Am I-
Mr. Singh. He's appearing.
Okay, okay.
On 30.
Yes, yes, here in Nazareth.
I am
Singh.
perhaps not audible, my lord.
Huh?
Interim line, no?
Uh, Mr. Singh, learned senior, heard Mr. Singh, learned senior counsel through video conferencing, through virtual mode, assisted by Mr. Ganguly, who is present here.
Obliged.
Yes.
Item number 3.
Yes, Mr. Mohanta,
Why
what you
not?
do?
This is second time. My lord,
Second-
I am only one thing, my lord.
Second time,
Yes, my lord.
where is the earlier order?
Earlier order I did not annex, my lord, but I have mentioned my lord specifically. my lord.
Where is that order? Who passed this order?
My lord, this is passed by lord, my lord, Rumi Fukun, my lord. It was long back 2021, my lord.
We'll call for the case there.
Yes,
Difficult.
Well, one prayer, my lord, just one, my lord. Just bear with me, my lord. This is admit card. This is a mark sheet. My lordship have a look at the mark sheet, my lord.
What is the finding in the earlier case as regards?
CD says that I am my lord, involved, but so far my lord, my admit mark sheet is concerned annexer 6 at this petition, my
You
lord.
have not been arrested till now.
See, but the time accused has been
It is not-
arrested. But my lord, only my one protection, my lord, I will appear before the IO. Just I will give this statement of the document my lord produced. This is only.
Let us see, we may grant you the relief. Let
Yes.
us see the case
Um,
there, how
up-
much this
updated
has
case
been
diary.
improved, huh?
Updated case there, madam.
After the case there. That's
Yes.
why we'll see, what in the meantime, how much they have progressed, whether your custodial intervention is required, it is. What about your job?
Already I am suspended and I am removed. My lord, this already the
Okay.
petition has been
Okay.
filed. My lord, challenging
Okay,
that
we'll see. We'll see on, what are going to have this?
5-6, madam.
5-6. CD 5-6. No, that he had to all of it material. He's giving it a CC data they call it.
5 to 6.
Please, your lordship.
Huh?
Your
You
lordship.
said doctor said something, this matter.
No, in the next one.
Okay.
6. Your lordship, on 11/10/2023,
Hmm.
the police had received an intel that some drugs were concealed in the house of one Asaruddin.
Where is the affair?
The FIR is at page 13.
Yes, 3,
1/3.
1-3.
Yes.
I was looking at 3-0. It is searched or not? Searched, scan copies are there?
Yes.
Okay, where is the affair?
It's 13.
Let us do one thing. This scan copies method will take a little bit later. Let us start from 9. Okay?
Obliged.
Musumi 6, 5, 6, 5, 6, 7 and 8. Call a little bit later. Then call 9.
Wait, please, your lordship. Lordship, this is a 439 bail application, lordship, 29 days in jail custody, lordship. FIR on page 16, lordship, page 14, lordship. Kindly see the.
CD not received.
379, lordship, 29 days, lordship, nothing recovered from this petitioner, lordship. Two-person,
Page,
lordship,
page FR,
on page 14, lordship.
what is the vernacular?
That is in vernacular on page 16, lordship.
Lordship finally comes to the forwarding, Lordship. Okay, when?
Fast forwarding,
Lordship,
that is on page 18, lordship.
No, not today, not without CD. 30, Lordship.
Lordship, it's from Sadgaon, lordship.
She's saying when 33
30.
Can it be on Friday, lordship?
Friday not
Friday
possible, 27th, Monday, okay.
Hello.
CD 27. CD not received, silo.
May I please? My lord,
Yes.
this matter wrongly listed in hearing column, otherwise this is motion matter, my lord.
Motion.
My lord. I am behind working 7, but my lord,
What is the FR?
my lord, page number 8, my lord. Already the vehicle recovered, my lord. I purchased one old vehicle, my lord, for rupees 30,000. I paid 15,000, but I could not pay rupees 15,000 in time. That's why this hazard has been lost, my lord. And I have been forwarded. Only I have annexed the seizure list, my lord, page number 18, my lord.
When? Sharma?
Lordship,
When?
System.
Tuesday, next Tuesday.
Tuesday?
Can it be possible on my lord 27, Monday? I live.
But without CD difficult, huh?
Already recovered, vehicle recovered.
That I know. But whether you are only this vehicle or you are doing with others, that
This is
will.
the vehicle, my lord.
So that's why you take a chance on Tuesday. Mr. Sharma, have it Tuesday.
Lordship. Lordship.
20.
Yes.
May I please, your lordship, this petition is filed for quashing of criminal proceedings, my lord.
Difficult.
My lord, they have, there is a long standing relationship and.
I understand.
But later on, this was culminated into marriage, my lord.
Then
Then
now where are they?
now
They are living
wife,
happily.
now wife has filed a DBX case. I am relying on the Supreme Court decision, my lord.
No, Supreme Court decision will come. Supreme Court decision is very clear. We will have to prima facie things say that on the reading of the FIR, no case is made out. This is one. Case is made out. And whether there was intention or not, or whether it's 420 or 376, this will come at later stage.
After
This requires
after
an
3 years of relationship, they have, the informant has filed the FIR, my lord. After 3 years of relationship.
And what about this DV case and all?
TV case, I am appearing in this.
When these DV cases were filed?
TV case is filed soon after 2-3 months of marriage, my lord. It was filed
So
in the year
DV case,
2002.
when marriage took, as
Marriage-
per her, in
marriage-
terms of DV case, when the marriage took place?
2022.
21,
2022.
2022. And FIR was lodged
It was lodged on 9/7/2022.
9/7.
2022.
What is her stand in the DV case?
Regarding domestic violence,
No, what is
demanding-
her claim? She is,
demanding money.
no. She says that I am married to
Yes,
so and
it's
so, so and so.
paragraph number 2, page number 31. That the aggrieved person was married to the respondent number 1 on 21/7/2022 as per Mohammedan law and Shariat. He admitted the marriage took place.
Heard. Ms. S. Roy, Learned Counsel for the petitioner, and Mr. B. Sharma, Learned Additional Public Prosecutor. By filing the present application under section 482 of the Code of Criminal Procedure 1973, the petitioner has challenged, petitioner is seeking quashment of FIR registered as Fakiraganj Police Station case number,
25 of 2022.
case number
125 of 2022.
125/2022, registered under section 419 /376/50 IPC. Full stop. The further challenge made in this petition is order dated 26/9/2023, by which cognizance of offences offences under section
Section 419, 376 and 506.
506 IPC has been taken by the learned
Chief Judicial Magistrate Dhubri.
Chief Judicial Magistrate Dhubri. Referring to a petition, the material available on record shows that the informant in Fakiraganj PS case number 125/2022 had filed an petition under section 12 of the Protection of Women from Domestic Violence Act 2005 before the court of the Chief Judicial Magistrate Dhubri, which was registered as CR within bracket D/D capital D/capital V, case number 764/2022. In the aforesaid petition, the informant has described her as married wife of respondent number 1, and according to her, the date of marriage is on 21/7/2022. According to her, such marriage was solemnized as per Mohammedan law and Shariat by executing marriage kabin nama. On the other hand, prior to that, on 9/7/2022, the impugn FIR was lodged, inter alia alleging that the petitioner has had sexual intercourse with her on the pretext of promise to marry her. Full stop. From the undisputed document of the DV case within bracket Supra, it is clear that according to the informant herself, the marriage was solemnized on 21/7/2022, that is after lodging of FIR on 9/7/2022. Full stop. Considering full stop. Uporote dibo application issue notice returnable tar pisot ekhini dibo. Considering the above, this court is of the view that the petitioner had been able to make out a case for an interim protection. Accordingly, it is provided that till the returnable date, further proceeding of PRC case number
1384 of 23.
23 pending before the learned Chief Judicial Magistrate Dhubri shall remain suspended.
Much obliged.
May I please, Your Lordship, this is for 39 application.
After some time, looks. Lordship had directed me to take instruction whether service of notice has been done or not. Lordship, on 18/5, we have communicated to the IO, and he has communicated today morning, Lordship, that due to some difficulty, Lordship, he could not serve it.
So when will he serve?
In 2 days, Lordship.
We are taking it on Friday.
Lordship. Lordship.
You just give the report that it has
Lordship,
been served. Otherwise, this man is, I think, is entitled for it.
Friday.
Yes, Your Lordship, she has said that nothing is done.
Yes,
I understand, but procedure we cannot.
I will ensure, Lordship.
Mr. B. Sharma, Learned Counsel for the Learned Additional Public Prosecutor, submits that the concerned IU has informed him that the service will be completed s- the notice shall be served upon the respondent number 2 by the officer in charge within a period of 2 days from today. Considering the above submission, the matter stands adjourned and be listed on 24th, so and so, comma, on which date the learned additional public prosecutor shall place the proof of service upon the respondent number. List accordingly.
The document petitioner in interim, my lord. He has appeared on 14/1, my lord, as per direction of his honorable
Where is
court.
the FIR? CD is there?
Yes, Lord.
Where is the FIR?
FIR, my lord, page number 14, my lord, 14. There is a long FIR, my lord. 406/420, my lord, regarding an amount of 15,000 loan taken by the petitioner, my lord. Sorry, my lord, the informant from Bandhan Bank, my lord. And
Who are you?
I am the, my lord, the employee of the Bandhan Bank.
Now, what is the allegation? Then what happened?
Then what happened, my lord? He did not refund the amount, my lord, 15,000 amount, my lord.
Ah,
And the informant and petitioner had a very good relation, friendship relation. And what happened, my lord? The informant had an earlier loan of another bank, two-wheeler loan, which is mentioned in the FIR. And he defaulted in that loan, for which he is not eligible, my lord, for the loan, my lord. So he requested the petitioner, my lord, due to friendship relation, to by taking loan on his name, to give him to the petitioner, informant. Accordingly, my lord, on the request, my lord, since the informant's brother was in medical, my lord, treatment, so he take the loan and given to the informant, my lord. Informant, my lord, but did not refund the amount, my lord, 15,000 amount, for which, my lord, the petitioner herein, my lord, he managed to take from another person this amount and give the paid the bank, my lord. Subsequently, what happened, my lord? Without repayment of the amount, he want to take back the, my lord, the gold earring, my lord. Accordingly, my lord, the petitioner and the informant, my lord, page number 18, they in the house of the informant's advocate, my lord, is page number 18.
Sharma,
Lordship, all these are subsequent facts. He has appeared, Lordship, but
appeared.
complicity is there, Lordship. He has done a sort of a fraud, Lordship.
What he has done is he has taken the money from the loanee
Yes.
and he has not deposited in the bank.
He has not deposited and he has deposited the amount in his account.
Ah.
And no loan account was opened in the name of the informant.
Ah.
Now, Lordship,
What happened to the gold?
gold has already been auctioned, Lordship.
Who auctioned? The bank auctioned.
Bank
So,
officials.
if gold is with the bank, there must be a loan. Loan is in.
Loan, Lordship, he has taken the loan in his own name, in his personal name. 18,000 rupees. He gave 15,000 to the informant. So he was happy. Afterwards, when he wanted back the loan, wanted to repay the loan, Lordship, the gold could not be given. The bank manager, Lordship, what he has stated is,
Who is he, this informant?
he is one of the employee of the bank. He was in charge of the processing of the loans, Lordship. What the bank manager has stated, Lordship, that the petitioner, ex-employee of so-and-so, he has worked in gold loan section. The branch manager stated that as per their record, there is neither any loan account in the name of the complainant nor 15,000 deposited in his savings account. Also stated that Bandhan Bank is no way liable for the gold loan availed by the complainant because it has already been auctioned off. So the fraud has been done by him. And when the informant was trying to get back the loan, he was giving evasive reply. He did not mean the informant. Afterwards, they entered into an agreement. He repaid the amount. That is the case, Lordship. So
Agreement
what has
on
been
page
done?
number 18, man.
Huh?
Page number 18 is the agreement, man. For a moment, man. There is already in the house of the informant's advocate, my lord. He agreed to repay the loan amount, my lord.
Only after
Page
the
number
FIR was
18.
closed.
Have you repaid now?
Yes, my lord. Repaid, my lord. Page number 18, my lord. His signature is there. Informant signature is there, my lord. Page number 18, my lord. The petitioner repaid the loan, my lord, but the informant did not pay, my lord. May I read, my lord? We both are the permanent residents of the aforesaid locality. Today on so and so at about, we have assembled at the residence of Advocate Ali Raja. Ali Raja is the advocate of the informant, my lord. And on the basis of the respective documents, we came to the decision that second party is the informant, kept the gold of first party in his account, and 15,000 of the gold with the area amount will be paid by the first party.
Which first party?
First party, my lord, here, my lord, Miss Baharul. First party, my lord, this Ekbal, my lord. Ekbal is the first party, informant.
Iqbal is informant.
Informant. Ekbal will pay the 15,000 with arrear amount. That means he did not pay the EMI, my lord. Will be paid by the first party, and the second party, that is the, my lord, petitioner, my lord.
This is an agreement when it was.
My lord, it is, my lord, vernacular is, my lord, page number 19, 9/7/23. The
And
signature,
when loan was sanctioned,
loan is of 2020, my lord,
and this agreement is
23, 23, my lord. Signature of the advocate is also there, my lord. In the vernacular, my lord, page number 19, my lord.
you are Misbahul Haq Choudhury,
Smith Baharul, yes, my lord.
and the informant is
Informant Ekbal, my lord, he is the first party, my lord. First party is the informant, my lord. Ekbal and Miss Baharul is the petitioner, my lord. So, my lord, friendship relation, my lord, he had paid the amount, my lord, but the informant defaulted, my lord. He is admitted, my lord, in this document, my lord, that he did not pay, and he will pay the amount with arrear, my lord.
now it is shall be whether this has been done.
This, my lord.
Ah,
My lord, this interim is given on 4/1, my lord. We have provided to the concerned police station, my lord.
Ah.
January, my lord.
whether the
Now,
statement of the victim,
To be taken again, Lordship, because
statement of the victim, this
Victim
this
is
is up to
up to Lordship, 9/11/23 is the last news, Lordship. I will have to update it, Lordship.
now. Where is the statement of the victim that she has received back the money?
You know,
Lordship,
updated,
that is
maybe
not
will
there,
call
but
for,
his
my lord.
agreement is in the case diary, Lordship, but his statement.
Anything you send
No.
back the state, we will not let him go like this.
Lordship, then I may be allowed to update it, Lordship.
Okay. Mr. MZ Karnik, full stop. Mr. Hard, Mrs. MZ Karni, learned counsel for the petitioner, and Mr. B. Sharma, learned additional public prosecutor. The present application is filed, so in so it is the contention of the full stop, referring to annexure 2 within bracket page 18 of the petition. Mr. Kadir, learned counsel, submits that the informant and the petitioner have settled the dispute
Yes.
in as much as the petitioner has already paid already returned the equal amount of loan, gold.
No, my lord. Loan amount to the bank, my lord.
All,
Petitioner paid the loan amount to the bank, my lord. Informant loan amount to the bank, my lord.
and what about the gold?
Gold from another person he took, my lord, the amount, my lord, and paid the bank. And my lord, this agreement, the informant will pay the amount, my lord.
So if situation or allegation is this, the informant gave you a gold
Yes.
and has taken a loan of
Loan.
15,000.
Yes.
Is that it?
Yes.
Now loan was not paid, so
Yes.
gold was auctioned.
Yes.
Now loan is paid. That is fine.
Loan not paid, my lord, by the informant. The
Uh,
petitioner paid, my lord.
Okay.
Petitioner paid
Yes.
the loan.
Yes,
That
ma'am.
is fine.
Yes, my lord.
Now what about the gold?
Gold, my lord, the informant will pay the amount, my lord,
Ah.
with arrear, my lord, and he will take back the gold, my lord. This is the agreement, my lord.
Okay, that is what I am saying.
Yes.
That is it, because loan payment is done, that is
Yes,
fine,
yes.
but where will the gold go? Because
Gold
the
and
bank has sold it already,
Yes, ma'am.
auctioned it.
That is-
He called us, sir. Dispute, and the informant has agreed, the petitioner has agreed to repay the
Return the
loan as well as return the gold.
Only the gold will return, my lord. Informant will pay the amount. my
Okay,
lord.
okay, and decided to return the gold. Full stop. However, Mr. B. Sharma submits that nothing is discernible from the case diary in this regard. That being the position, he submits that he may be allowed to return back the case diary so that the IO can update and incorporate the statement of the victim in this regard. Prayer is allowed. Please this matter
7th of June, Lordship.
on 7th of June 2024. Interim order pass earlier shall continue till the next date. You too.
Your Lordships. So, 38 application, your Lordships, I was on the interim, your Lordships.
and they.
I was here, Mr. Sharma.
Lordship, yes, it is your lordship.
Where is the FIR?
FIR is page 23, your lordships. Wherein the informant has stated that she was introduced by me, your lordships, for purchasing her plot of land. To she approached me for look after a purchaser for her selling of her land, your lordship.
Mm.
I introduced her persons, and thereafter the sale has been obtained. Agreement was executed, and subsequently the land of that property has been subsequently buy by the different persons, your lordship. There's nothing point out any single requirements regarding the fraud has been committed by me, your lordship. Even she
Now,
also.
what happened? So, you have introduced a person, they entered into an agreement, land was sold. Now,
Land
what
was-
is your allegation against you?
The allegation against me, nothing, your lordship.
No, what is the allegation? Against you, there is nothing. What is the allegation?
The thing is that the persons who has been purchased the land, your lordships,
Mm.
he in connivance with me has fraudulent some documents, your lordship. That is the one of the allegation, your lordships. And but the thing is that the FIR himself stated that at the behest of me, that the fraudulent activity has been come to her light, your lordship. The land has been subsequently been purchased by different person, your lordship. It is a matter of civil dispute. If it is mandatory dispute, your lordship, she came to the court of civil jurisdiction for the recovery of her money, your lordships. And if it is allegation, your lordship, if the FIR has not been stated, your lordships, why I have been implicated, your lordship.
Also, may I clarify, lordship?
The sale was also cancelled.
Can I clarify, lordship?
Yes.
Also, what has happened, the informant first entered into a sale of agreement for sale of land with a particular person called
Kalipodo.
Kolipod De.
Hmm.
Subsequently, it was cancelled, lordship,
Mm.
because of some consent, lordship. Then lordship, and he was the broker, lordship. The middle-
In case of Kalipodo.
Yes.
Mm.
Then lordship, subsequently, the informant wanted to sell the plot of land to another person.
Mm.
So again, he was asked to take out the requisite permission, lordship. And thereafter, lordship, the informant came to know that one portion of the land has already been sold off,
By him.
not by him, lordship,
Mm.
to another two accused person, lordship.
Harlan.
Another person,
Mm.
lordship. Now, lordship, when he went there, filed RTI, he came to know that a power of attorney has shown to be executed by the informant
Mm.
in the name of one person by the name of Umar Shankar De,
Okay.
that he has executed that power of attorney. Subsequently, when investigation was done, lordship, it was found that that power of attorney is a fraudulent one.
Mm.
And the office of the sub-register also stated that this power of attorney could not be traced out in our office. Subsequently, lordship, when the investigation came, it was found out that his involvement is, lordship, he had given the PAN card identification paper of the informant to this person by the name of Kalipat De, who is the prime accused, along with Uma Shankar De. And they manipulated the informant's ID card, attaching another photograph of another person.
Understand?
Yes.
They first entered into the agreement with a
Yes.
Kalipodo with the intention
To-
to have the documents first.
Yes.
Then that
Yes.
after
Yes.
getting the documents, the agreement was cancelled.
Yes.
Now they use those documents to
To-
convert into a power of attorney. Then from the
Because of
basis
that-
of power of attorney, land was sold to somebody else,
Yes.
one person.
His involvement is, lordship.
Only his involvement is that he facilitated this.
He facilitated it, and then, lordship, he also deleted all his data from the mobile phone, wherein he has given this identification paper to the prime accused. But on his phone, it is clearly revealed that he had supplied the photographs. Next, lordship, the original fraudulent deed, lordship, that is nowhere to be traced out. Nobody is cooperating, and all the accused are shifting the blame to one another.
It's a-
It is
One
the
thing
case.
is the Kalipat De has been enlarged on granting privilege bail, and the bail has been absolute, your lordship. Second thing is, your lordships, the very FIR clearly stated that at the behest of.
Where is the Kalipodo's bail order?
No, this is the bail, I've already submitted a copy of the order, Your Lordship. On 18/10/2023, he has been granted the privilege of enlarge of privilege bail, Lordship. Subsequently, that bail has been absolute.
To be fair, Lordship,
Lordship,
to be very fair, Lordship, from the statement of the other co-accused, his involvement is
Limited.
limited and a little on the white side also. Maybe he had done it with a good intent. We cannot say from.
May not, he might have because he facilitated.
Yes, yes.
So earlier agreement.
Yes.
So he said, give me the, because he's the middleman. He got
Only-
it from here, he sent it to this.
Only, Lordship, because he deleted
Hmm.
and giving evasive, that is the gray area.
Okay. Heart,
Yes,
Mr.
yes.
So learned counsel for the petitioner and Mr. B. Sharma, learned counsel for the additional public prosecutor. The present application is filed under so. The basic allegation lodged in the affair is forgery of certain documents. Full stop. Full stop. Case diary. This court under this order dated. Which order? Order dated. Order dated 1/3/2024. Granted interim protection to the petitioner. Full stop. Case diary is produced by the learned additional public prosecutor. Full stop. Same is perused. Perused the same. Perused the same. Full stop. From the material available on record, it is seen that the petitioner has fully cooperated with the investigation, and his statements were also been recorded. Full stop. The material so far collected, and after perusal of the material so far collected by the investigating authority, this court is of the view that the custodial detention of the petitioners may not be necessary in this case. May not be necessary in this case. In as much as the investigation has substantially been progressed. Full stop. Accordingly, the interim order passed earlier dated so and so is moved out.
Please, Your Lordship.
Yes.
It's a second bail application, Lordship.
Hmm.
It was earlier rejected by your Lordship, actually. The FIR, Lordship, will find at page 8, Lordship.
It is, yeah.
Yes, it is there, man. Page
This
15
is
is the
BA or AB?
AB, my lord. Page 15 is the rejection order.
The allegation, Lordship, was that
But these are not cases of anticipatory. We'll go there, come back, we'll give you. bail.
material, sir, who was there with him, Lordship. He has been granted bail, Lordship, anticipatory bail.
Where is that?
That order is there, Lordship.
Huh?
At page 20, page 17, Lordship. He was also with that in the same 43 persons were there. This was, although materials were there, but it was granted in. Here, apart from the sections, Lordship, these all are bailable section, Lordship, except 365. And there was no kidnapping, Lordship, because as per the FIR itself, Lordship, the allegation. They said that after taking the money, they were dropped from the vehicle.
Who is this man?
This man also
Thompson.
is
Where is the
alleged to
affair?
be in-
Where is the affair?
page 8, Lordship.
Yes, what is his role?
His role is a little bit more specific, my lord,
Hmm.
because the amount that is 50,000 was
Yes,
paid
transferred to his
trans-
account.
his
That is
account.
why we have rejected.
as his account, my lord, specifically. And others are my lord, similar, and
The person who was granted bail lordship, he was, as per the allegation, he was also their lordship.
he's along with him, that
Yeah.
is in the same vehicle. my lord.
Okay, we'll take it up this matter next week. We'll think over it. Next week. On the prayer of the learned counsel petitioner, release this matter next week. We'll go through the CD on
Lordship.
Lordship, may fix a date.
Monday.
Kindly take up this matter tomorrow.
Item.
Item 14.
Tomorrow not possible.
আগতে নকয় কি?
We'll take it up on Monday.
My lord, kindly maybe on Friday, my lord. Mr. H.R.A. Chaudhary will not available on Monday.
When will he be available? Tomorrow not possible.
Then Friday, my lord. Friday.
Okay, we'll give a chance.
They should inform us because we are having hard time seeing the scan copies. my lord. We
That
have
That is,
again, we are
yes, that
prepared
is,
it and my lord, they are taking. it.
they should inform.
That's it. At least you should
This is
inform
this
earlier, no?
earlier rejected or what?
Rejected, my lord.
That murder case,
No, I mean,
Other, my lord, is
Huh?
case of suicide, my lord, what I,
that vehicle.
not vehicle. The hanging, my lord.
PM is something different.
Something different. We have seen that.
Friday, my lord.
These cases anticipatory bail
Lord.
different. This is why scan copy search it file.
The search sheet file my scan copy came, my lord.
Now they are coming.
They are
AB.
coming after that.
Bail kita hasil na? Mati rin.
Item number 5.
Yes, orders.
Calling my please.
Orders, not orders.
Last. They-
Okay, let the orders be finish.
Take-
this.
For orders.
May I please, your lord?
Yes,
Lordship, this application is filed for modification of order dated Lordship 11/3/2024. For modification of order.
where is
dated,
that? What kind of modification?
Lordship, I have stated in paragraph 3, Lordship, page 4, Lordship.
Paragraph?
Page 4, Lordship, IA, Lordship. Belongs to a poor family, Lordship. Not arrange the one of bail or Lordship, security, Lordship.
Yes, you want one surety.
Lordship.
NDPS.
NDPS, that is why 2 COTs are given. As on today, Lordship, 2 years, Lordship, 2 months, 10 days, Lordship, elapsed, Lordship, after date of order, Lordship.
Where is your residence?
He is a local residence, Lordship.
Huh?
Local residence, Lordship, from Lordship.
Heard, Mr.
Ayu Chaudhary.
Ayu Chaudhary, learned counsel for the petition. It will open up a decision application. It may open up everything anyway. Okay.
Conditions are
Decision
at page
application
11.
for modification of order dated 13/11/2020. This application is filed for modification of order dated 11/3/2024 passed by this court in BA number 342/2024. By the aforesaid order, the applicant was granted bail in connection with
Special NDPS case number
special NDPS case number
114 of 21,
114 of
2021,
2021
arising out of Karimganj PS case number
arising out of Karimganj PS case number 1171/2021 under section 20 within bracket C/29 of the NDPS Act. While granting bail, a condition was imposed to the effect that the petitioner will have to provide. Where is that?
Page 11, Lordship. Page 11 is para 18, para 18.
Provided that para 11. The petition by the efforts of the petitioner, petitioner was granted bail on executing a bail bond of rupees 1 lakh with 2 suitable solvent sureties of like amount to the satisfaction of the learned special judge Karimganj, Assam. Full stop. It is the contention of the petitioner that the petitioner belongs to very poor strata of society and he could manage only one surety and has not been able to one surety and therefore he still languishing in jail. Full stop. If the condition of 2 sureties is relaxed, he will be able to come out from the bail. What you say?
Otherwise, that is the difficulty.
Okay, issue notice returnable forthwith. Please this matter on Monday next. On Monday, on Tuesday next. Give it to us. Give it to us. On Tuesday next. Tuesday next, Mr. Goswami accepts notice on behalf of the state. He full stop. On the next date fixed, Mr. Goswami shall obtain his instruction or file objection if any.
Number 6, Lord. I have
Full
only
stop.
one copy, Lordship. Yes, I have marked it, Lord. Sorry, 82% sign. Listen to person sign.
Okay. You want a copy? Give a copy
I have
in the,
Lord.
okay. Full stop. List accordingly. 28.
Obliged.
Let the state have a chance to.
Obliged.
It should not be day one. Yes, next.
Your Lordship. This is IA, my lord. We have filed for reconsideration of order dated, my lord, 18/8/2022, my lord. Order is at is 14, my lord.
18/8.
18/8/2022, my lord. Operative portion at page 15, my lord. Third paragraph.
What is your ground?
My lord, ground is, my lord, as per statutes, my lord, it mentions that whichever is lesser, my lord, as per section 173, my lord, though if it, my lord, 50%, then it comes to, my lord, 35 lakhs, my lord. Then and statute says, my lord, 30% or 25,000, whichever is lesser,
MSC Act.
my lord.
That is for, what is that provision? Read it. Yes, what is the provision? Tell us.
My lord, 173 appeals, subject to the provisions of subsection 2, any person aggrieved by an award of a claims tribunal may within 90 days from the date of award refer an appeal to the High Court, provided that no appeal by the person who is required to pay any amount in terms of such award shall be entertained by the High Court unless he has deposited with it 25,000 rupees or 50% of the amount so awarded, whichever is less in the manner directed by the High Court.
That is a statutory deposit.
My lord.
Okay.
My lord.
According to us, this is a money decree. So when it is a money decree, CPC is in certain cases applicable 50% deposit. Dismissed.
My lord,
Order to follow.
my lord, may very well knows, my lord, ACC is a loss-making corporation, my lord.
Huh?
ACC is a loss-making corporation.
We do not know.
We have
Loss
stated-
making corporation liquidate it.
We have stated in our petition, my lord.
Dismissed order to follow. Yes.
Okay.
Huh? Oh, fine. This is a 2014 MSc appeal. When matters were listed, people will not come forward for hearing. Yes.
My lord, in this matter, my lord, just I have received a my lord WhatsApp message, my lord. Matter has been, my lord, personnel department has given his view. And Ashok Burman is a sincere officer, my lord, retired officer. He's working in the OSD in the chief secretary office, my lord. He told me that, my lord, another 4 weeks time may be granted so that with that view of this matter, they will provide me instructions. Otherwise, I have received a paperless comment from the Deputy Commissioner.
We'll not say anything. We'll say, but next, after, we'll giving you 3 weeks time.
Yes, my lord.
Thereafter, no further time.
No
We'll
further time.
proceed on our own.
Yes. No,
Okay.
they are taking now. They're
Okay.
taking up.
Because of this election and all, okay, we can
Yes,
understand.
yes, yes.
Mr. T. Chutia, Learned Counsel for the representing the state, submits that he has received instruction and preparing the affidavits. And also he has sought for certain further instruction. Accordingly, he submits that by next 3 weeks, he will be able to file the affidavit in question. Accordingly, he seeks for an adjournment. Prayer is not opposed. Such prayer is not being opposed. Such prayer is not opposed. Full stop. Accordingly, same is allowed. List this matter on 12th of June.
Oh, bless, man.
Five.
Deeply obliged, my lord.
Yes.
Earlier matter, I appear and we have to respond.
Okay. J. Handy for respondent number 2.
Your Lordship, on 11/10/2023,
Mm.
police received an intel which says that in the house of FIR page 13,
Page 13.
13, yes.
What is your name?
Aisha Begum. I'm the wife of Asaruddin.
I think I have dealt with this case earlier.
Oh, Your Lordship.
Somehow. Any order passed by this court?
Not this court, Your Lordship. Learned, Honorable Judge M.K. Galita heard it once.
Any order passed
Here.
earlier? Earlier rejection, earlier.
No.
This is the first time.
This is the first time.
Okay. Well, where is your husband now?
He is an absconder, and instead of him, I was arrested. Now, on the previous day, I have admitted in the during interrogation that one Your Lordship, another person came and gave one green color bag to my husband, and he kept that bag somewhere. And on the next day, I was arrested. Now, I am not
Well,
knowing
what
what
is
are
the
the
stage of
Your Lordship, it has been fixed for appearance. And Your Lordship will find that I was arrested on 12/10/2023.
12/10.
10/2023. And since till today, it has been fixed for appearance. The next date is fixed on 30/5/2024. So literally, there is no progress in the case. And I am inside the jail since 12/10, along with my infant son, 1-year-old son.
difficult at this stage.
Your Lordship, considering the circumstances, Your Lordship may consider my bail. Because it has been.
Let at least the seizure witnesses examine.
Yes.
Then only we can consider.
Your
You
Lordship
make
may-
a submission that you will approach this trial court after examination of the seizure witness and will provide that these trials be expeditiously proceeded.
Your Lordship, another thing is that section 42 of the NDPS that has also been violated. Because the information was received, that information was not taken down in writing.
These are true. But a little bit you have to progress. We'll provide that. It's difficult. If you want the senior doctor to come, we'll fix it on Monday.
Then Monday. Your
Okay. On the prayer of Mr. S, on behalf, a prayer made on behalf of Mr. S. Datta Lanet, Senior Counsel for adjournment of the case. Prayer is allowed. Please this matter on Tuesday. Next.
Obliged.
Number 7.
Please, the lordship.
Yes.
My lord, these two petitioners for your lordship is the driver and helper of a truck, my lord, whose vehicle were placed under the displacement of Om Logistics, my lord. They were entrusted to transport the goods of Om Logistics, my lord, from Guwahati to other places. Now, what happened in this case, my lord? During a Naka checking, may I take a lordship to the FIR, my lord? Page 10, my lord. During a Naka checking, my lord, these vehicles were stopped, and when search was conducted, my lord, from packet 20 numbers of packet, my lord, containing papad, Marwari papad, some 1990 bottles of escapes were recovered, my lord. And accordingly, my lord, these two petitioners were taken into custody. Here is at page 10.
What is the stage?
My lord, it is last date was fixed on 17/5 for evidence, but it was not recorded.
How many witnesses are there?
My lord, 10.
Huh?
9 witnesses, my lord.
How many examined?
Not a single witness examined, my lord, till date.
So far seizure is concerned, my lord, they are on conscious possession of both these petitioners, my lord, and
Conscious state.
consistent. And your lordship will kindly peruse the 8/2/24 order, my lord. I have flagged in the scan copy of green lordship, and your lordship will find why cannot be examined.
My lord.
4 of them appear.
I just please the facts, my lord.
No facts you have seen. You are remember that you are in a NDPS case.
Yes.
Recovery is from the truck in a concealed state, and you are the driver and handyman of the truck.
Yes.
Just remember that. Then you also remember that when 4 of the witnesses were present out of 9, an adjournment was sought on your behalf.
It was actually not stated to me, my lord.
So
At this
this
stage,
was the first date, and they produced 4 witnesses. And you took adjournment again. Next date it was fixed on 2/4. 2/4 against
again,
issued. So 17, 5, we do
17.
not know.
17.
Rejection or withdrawal at a liberty to come at a later stage. Approach the session judge.
We'll approach
Or rejection with the ground that these are the materials. So in terms of section 37, we are not satisfied that he has made out a case for bail. A matter ends there. No scope for session judges.
We'll approach my lord at later stage.
Huh?
We'll approach my lord this later stage. Only one thing, my lord, these goods were, my lord, booked at Patna, my lord. And from 4 different vehicles, my lord, from 4 different transshipment points, it reached Guwahati. And thereafter, my lord, I was entrusted, the vehicle was loaded with these goods, my lord, along with other goods also. The consignment notes we have annexed, my lord. It starts from page 36. And lordship will
We
find, my-
understand, but ultimately at the moment of recovery, whether actually it is conscious position or not, so there will be some more material to give you a bail, even a bail. As on that death stage has not come. You might have a good case after examination of these witnesses.
These are witnesses.
Because 37's rigor is there.
I understand.
These are not the stages. Had it been that you are no witnesses are examined, you are long incarnation, then we can give an additional benefit taking note of Article 21.
Long
But that this stage has not come.
It is not there. Long
If it is not there, we'll have to reject saying that 37. Then you will have to come after 2 years. So tell us what to do.
After examination of my lord, material witnesses, will approach this court, my lord.
Learned counsel for the petitioner submits that he may be allowed to withdraw the present application and approach the learned session judge. Learned trial court. Full stop. He further submits that he may be granted liberty to approach this court once again. Once again, full stop. Prayer is allowed accordingly. This petition stands closed on withdrawal with a liberty to approach this court if necessity arises after examination of the seizure witnesses.
Well, 439 application, my lord. Earlier application, my lord, case there was called for, my lord. My lord, a young boy of 18 years of age, my lord. Without any fault, my lord, he is in jail from last 56 days, my lord. So lordship might kindly see the FIR page 9, my lord.
Charge sheet is filed.
No, my lord, it's not touched.
Then why scan copy is called?
Possibly, my lord, wrongly, my lord, because it was not charged sheet, my lord. From this court, my lord.
Where is the FIR?
Page 9, my lord. Vernacular page 15, my lord. My sister also with us, my lord. 4 girls and 3 boys, my lord.
Where is the FIR?
FIR page 9, my lord.
Steps list, no?
Oh, it's still- it's not on the law,
No. Perhaps steps is not complete, man.
Oh, still law, sir.
Report 9. Okay?
No, if we reject steps is not necessary. We think that he has made out a case, then we'll approach.
Not.
Is there else, my lord?
Is there no? Is there because CD visation? CD, no?
Why scan copies? I am not
Yes,
understanding.
my lord. I have last location also, my lord. I paid for case diary, my lord, because it is not charge sheeted, my lord. And the court, my lord, given date, my lord, after 4 weeks, my lord. It is from Dispur, my lord. I even second time prayed for shorter date, my lord. My sister is also with me, my lord. On that day, my lord. It was occasion of Holi festival, my lord. Holi, my lord. They went out to celebrate Holi, my lord. 4 girls and 3 boys, my lord. My sister is also with me, my lord, on that day, my lord.
Mr. Goswami submits that he may be granted when
Monday, my lord. Already 60, near about 60 days.
possible.
Monday.
We'll try my
This
subject to
provision.
convenience of the court, my lord.
Tuesday, next
Yes.
Tuesday,
My lord.
not Tuesday, Wednesday, next
No.
Wednesday.
No, sir.
6 time to
Convenience
produce
of-
the case diary in connection with Dispur PS case number
262, my
Two
lord.
of 24.
262/24.
I have also taken, my lord, a step for officer in charge, my lord. Should I inform?
Huh?
I have also
Full
taken.
stop. The petitioner
Petitioner.
has,
Registry
it
per
is
question.
submitted that petitioner
question,
has
registry.
taken steps for service of notice
Registry per question.
upon the victim slash informant
For my lord, the order passed, my lord.
कितने को है? कितने लिखा? 24? 24/4.
For a registered AD as well as my lord, for officer in charge, my lord.
কমা কি করলো রাস্তাখিনি
Steps for service of notice upon the victim slash informant.
comma full stop. The office note also reflects that but you have not taken steps in terms of Deepak Nayak. You will take a fresh steps. You will have to give a copy to the office of the public prosecutor. Then public
Okay.
prosecutor will send it to the concerned. Full stop. The learned counsel for the Agorkini Katidia steps up. The learned counsel for the petitioner submits that he may be granted time to take steps upon the respondent number 2 as per the procedure laid down by the division bench in Deepak Nayak versus State of Assam.
Lord.
Deepak Nayak versus State of Assam. Prayer is allowed.
Respondent number 1, my lord. Have my-
Respondent number 1. Respondent number. Full stop. Prayer is allowed.
I will serve copy to him, my lord.
But Tuesday will be difficult.
1 week more time.
1 week.
My lord, kindly, my lord, because he is in jail, my lord. for
Because we have to
56
send a
90
copy.
days.
My lord, no offense happened, my lord. Medical
know
report
that.
will reveal, my lord.
See,
My lord.
happened or not happened, we'll see from the
Yes, my lord, kindly, my lord.
statement,
because-
victim. She said it was recovered from a Innova. What the person who recovered says, what is being said, what is the victim statement?
Because I personally.
We are not here doing any trial.
Because I am personally aware.
No,
of
don't, we cannot be personal in.
The victim and the accused person.
See, when you
in front
know
of my house, my
personally,
lord.
don't
Side-
appear.
side, my lord, my lord,
Don't appear when you know personally.
my lord.
These are not question of personal
My-
things.
my-
We will go by law. So take the steps.
My lord, yes, I'll take it.
Then we'll have to, we have a box here.
No, my lord, no.
That
my lord.
lawyer will give
I'm sorry, my
a
lord.
statement or no, that I know them, they
I'm
exist.
sorry, my lord. I'm sorry.
That should not be.
I'm sorry.
List this matter, give a date, not
On-
Tuesday.
4th of June.
Friday, my lord.
4th
Friday,
of,
June.
my lord,
4th
Friday,
of
my lord.
June.
Can it be on Friday, my lord? 18 years old age, my age boy,
Because
my
my
lord.
lord, again, we have
My
to
lord.
give some time to the.
Okay, let him
service.
have his happiness. Friday, which Friday?
Next Friday, my lord.
31st.
Next Friday, my lord, 31st.
31st.
Kindly, my lord.
31st.
My lord.
Okay, 31st.
Obliged, my
We'll
lord.
see. Take this. You take the steps first.
My lord.
Then they will have to send it. Police will have to report that served or not.
Police also have to go and.
Oh, then they will have to take a witness. It's not that easy.
Yes,
This is a mandate of law. What to do?
yes. That is why.
Yes, it.
Application, Lord, for 39 application. Accused is in jail from 28/9/2023.
Where is the affair?
FIR is from.
This is seated.
Yes.
Where is the affair?
Page 11, page 14 is the trusted copy.
Who are you? Why you have been arrested?
I am one of the accused. There are three accused. Other accused are already on bail. I have also annexed the copy of the order.
What happened?
Other accused person is already on bail. There are three
Bail
persons.
at what stage?
Examination of witnesses. I have
Huh?
just examination of witnesses. One PW.
Where is the order?
Order is on page 22. It is 4. Annexure 4. Later on, seen the report of
Page,
page 22. In the report of dealing resistance stated that CS has not been submitted in the so and so. Learned counsel for the accused has paid for granting bail, stating that the accused has completed statutory period and entitled to. Submission has to be made properly, my lord. Otherwise,
This charge sheet was not filed at that point of
otherwise, you're
time.
wasting of court time. My lord, they say that it is a pure default bail. My lord. So
Default bail.
sir, why
That is why I'm surprised.
My lord.
That was a two different stage. What is the stage now?
Witnesses.
Anybody examine?
Not exactly for, yes, sir. One witness, PW. That is not in the CD, case record, man. It is 7 till 7-3. And the lawsuit, my lord, I have
What is your name?
from Paul Biplov. With all respect, my lord, this is a case where I have seen, my lord, where the accused could go to such an extent, my lord. The lawsuit will just see the charge sheet, my lord, last page of the charge sheet, my lord. Though it is along with the charge sheet, that page is missing in the petition, my lord. I have flag mark, my lord, star marks, my lord.
Who that ATM card belongs to whom?
I think I'm accused person.
Huh?
Accused person.
Which accused? You.
All.
Hmm?
There are three.
No, ATM card. On ATM card was seized from the place of occurrence.
No, not identified. Your lordship will see the PM, my lord, and also the findings, my lord, in the charge sheet, my lord. The last page of the charge sheet, my lord. Box part, my lord, that's flag mark, star mark. ইয়াতে দুটা ঠাই নাই।
Close the session, just withdraw it. We'll make comment otherwise.
Yes, because that's if it is to be commented, my lord, then the lordships.
We know what will be the fate of this case,
Yes.
but not now.
Yes.
Learned counsel for the petitioner submits that he may be allowed to withdraw this application and approach the learned trial court seeking bail. He further submits that in the event such bail petition is rejected by the learned session judge, he may be granted liberty to approach this court once again. Full stop. Prayer is allowed. Accordingly, this petition stands closed with a liberty as prayed for. Yes. You want to add something, Mr. Chaudhary?
Yes, ma'am.
Yes.
The last occasion, my lord. Your lordship is.
That is what I'm going through those notes. Yes. We'll conclude this today. Yes.
Here, my lord,
Here basically the subsequent that implications of that evidence, piece of document.
my lord, whether it is a case of 302 or not, my lord.
This is basic.
That is very important in this case. Firstly, my lord, because he was injured.
Whether there is suspicion of 302.
Yes,
Suspicion, not a
Yes,
case of
yes.
Yes.
My lord, on the very day, my lord, he was injured at my lord 3. Occurrence is at about 3 p.m., my lord. And my lord, immediately, my lord, he was taken to Silchar Medical College Hospital, my lord. And from the injury report which I have annexed, my lord, lordship will find that he sustained only, my lord, injuries
In eye.
eye, my lord, left eye and right eye, my lord. So, my lord, from that only, my lord, with that injury, my lord, he survived for almost 28 days. So, my lord, whether there was intention.
What was the postmortem report cause of death?
That is, my lord, cardiorespiratory failure following septicemia. On the last occasion, my lord, I, my lord, pointed out to the, my lord, postmortem report. There was, my lord, not a single internal injury or external injury, my lord. My lord, for occurring a, my lord, septicemia, there has to be some, my lord, internal or external injury. But in our postmortem report, my lord, both are missing, my lord. So from which injury, my lord, his septicemia has developed, my lord? Again, I am repeating, my lord, that too after 28 days, my lord. He was treated at Guwahati. Then, my lord, his eyesight was better, my lord. So he went to, my lord, Karimganj. Then Silchar, my lord. So for about 10, 11 days, he was all right, my lord. From 31st to, my lord, 10th, he was all right. Then, my lord, suddenly on 11th, my lord,
Just give the dates.
My lord.
When just no, not
on the
necessary.
last occasion,
Ah,
Lordship has asked my junior to, my lord, give the list of that regarding Rinku Malakar,
all these
fathers,
dates.
my lord.
Okay.
So my lord, after getting treatment at my lord Sankar Netraloy, lordship will find from my lord his father's statement, my lord, his statement before police, my lord. So in the second page, my lordship will find when Ratnadi's eyesight got little better, doctor asked to come for checkup after 21 days. On 31/8/2011, came back to house at Karimganj. They came back to Karimganj. That is our type copy, my lord, which I have given just now, my lord. Just a minute. That's Rinku Malakar's statement. Your lordship has asked my junior to give a detailed list of dates.
That I have received.
Yes, my lord.
Now, page
Page, second page, my lord,
of the type copies.
of the type copy, my lord. Yes, sir, I have given, my lord. এই মাত্র যে দিছিলে, এই মাত্র দেয়া আছে।
No, no.
দিয়ে আসুক মাত্র পড়িছিলে।
Got little better. Doctor asked to come for checkup after
After 21 days.
20 days.
Then, my lord, on 31/8/2011, came back to house at Karimganj. So they returned to Karimganj, their, my lord, home, my lord. Then, my lord, from 31 to 12/9, my lord, there was no complaint. He was okay. Then suddenly, my lord, on 12/9/2011, when Ratnadeep felt unwell and started feeling severe pain in his abdomen and chest, 108 was called and taken to Karimganj Civil Hospital at about 2 p.m., my lord. Then, my lord, this treating doctor advised and all. Finally, my lord, he died on 15/9/2011 at about 4:45 p.m., my lord.
Okay.
So, my lord, coming to page 99 of my petition, my lord, Annexure 8. At page 99. On the very day, my lord, at about 17/8/11, the day of my lord occurrence, my lord. At 8 p.m., my lord, he was examined at Silchar Medical College Hospital, my lord. What doctor found, my lord? A cut injury on the, my lord, right eyelid and a, my lord, abrasion on the, my lord, left eye, my lord. And, my lord, besides these two injuries of the eye, my lord, no injuries were found. So, my humble submission before your lordship, my lord, whether, my lord, those, my lord, boys who assaulted, my lord, they had the intention to cause the death of the, my lord, victim, my lord.
Yes.
So, my lord, if we go to go by, my lord, this Annexure 8, page 99, my lord. Dear, my lord, it was mentioned that type of weapon blunt and nature of injury is grievous, my lord. And after this, my lord, he was treated as referred by them, my lord, he was treated at Sankar Netraloy. So, my humble submission before your lordship, my lord, whether these boys, they had the intention to cause death, my lord.
So even according to you, even if it is assumed that his last declaration is there, that may relate to participation, but on the basis of material available on record, it cannot be 302.
My lord, that
More-
is my submission, my lord.
That is a submission.
Yes.
More particularly for two counts. One is cause of death is septicemia. There is a gap of
28 days.
28 days from the date of occurrence and date of death. and the injury are not so, or it will not reflect that these people
Because of
had,
those injuries,
they
my
had intention or knowledge that this will cause a
Cause
death,
death.
so it will be a culpable homicide amounting to
I am
murder.
on that.
This is your
Yes,
case
yes.
basically.
My submission before your lordship. So, my lord, even we come to the, my lord, the post-mortem report. My lord. As my lord, submitted earlier, my lord, there is no mention of any internal injury, external injury. My lord. Suppose because of, my lord, eye injuries, septicemia has occurred, my lord. Then, my lord, that post-mortem doctor ought to have got some pass in those injuries, my lord. And as per the, my lord, Sankardev Netralaya Hospital, my lord, he is, my lord, he has improved, my lord, and he was asked to come for, my lord, checkup after 21 days.
Yes.
Post-mortem report, lordship will find at page, my lord, original at page 106, 107, my lord. My typed copy, my lord, at
Type
page
99.
my
Type
lord.
is 99.
Yes, not 99, ma'am. 99 is the injury report.
Injury report. Okay,
Yeah,
post-mortem.
very first day when he
Okay.
took, my lord,
Mm.
treatment at Silchar Medical College Hospital, my lord. PM report starts from, my lord, 102.
102.
Here also, lordship will find, my lord, no injury in the eye or any other parts of the body, my lord.
Mm. Okay.
So, my lord, in this injury report, lordship will not find, my lord, any internal or external injuries, my lord, while conducting the post-mortem examination, my lord. It has to be, my lord, relatable with some injuries, my lord.
Nexus.
So that is missing in our case, my lord. And my lord, last occasion, my lord, I have pointed out, my lord, even the, my lord,
Proximate cause. Not
proximate,
nexus.
there has to be
Proximate
proximity.
cause of death is not relatable to the injury
sustained by the victim, my lord.
This is your case. Injury cannot be said to be proximate, even if everything is believed.
Yes.
This is your case.
Yes, my lord.
নালাগে থাকো কৰিলে অলপ কৈ আছো 12:10 মিনিট পিছত yes
My lord, last occasion, my lord, I submitted, my lord, that in this case, originally, my lord, while submitting the search sheet, my lord, there is no 302.
yes
We have taken out the, my lord, the order of taking cognizance, my lord. Lordship will find just now I have given, my lord,
Yes,
those.
I've seen that. Yes. This is phase 3.
Yes, my lord, phase 3.
Yes.
Here, my lord, these 3 accused persons have been searched as absconder, my lord. Unfortunately, my lord, the police never charged them, my lord. Because their name came in the, my lord, that piece of paper given by the aunt. That was
That is subsequent.
subsequent after the death of the, my lord, the victim, my lord.
Yes. After the death.
But even after that, my lord, they were available in the, my lord, campus They were final year student, my lord, till my lord, 2012, my lord, May, June, they were there in the campus, my lord.
Here we are only for whom?
My lord, there are three petitioners are before your lordship, my lord, who were not named in the affair.
Here, who are the petitioner? Amit.
Tosi Kumar Datta. Then my lord Ravi Yadav. And my lord Himang Sharma.
Okay.
He is a my lord Himang Sharma. He got the my lord gold medalist, my lord.
Ravi Yadav, Himang Sharma,
and my lord Sasi Kumar
Shashi
Datta.
Kumar Datta.
They were not named in the affair. Only named person was one Amit Misra.
Amit Misra.
He could be identified by the my lord, by the victim on the very day. So his name reflected in the first information report.
He not only the victim, the shopkeeper,
Some other boys,
some
also,
other boys, shopkeeper,
they have
everybody.
stated. And that my lord, that barber shop
Barber
where
shop,
he went, my lord, he also told that he could identify Amit, my lord.
Yes.
So my lord,
And your another point, we'll come to that. Your another point was that even the charge frame is not clear. It should be specific. It is only ifs and buts.
Yes, yes. Last time, my lord, I just pointed out. My lord, that model form of charge, my lord, in a 302 case, my lord, what it should be.
Where do we get that?
That, my lord, this is a criminal measure act, my lord. Whether in my lord Ratanlal, Dhirajlal, it is here or not.
Any statutory prescription? It is under any provision of law?
My lord, how the frame charges is to be framed, my lord. Some model, and we find, my lord, most of the 302 cases, my lord.
Any statutory that's under CRPC that this should be the form and all anything? Just to look into that. Whether any prescription by any judgment that this should be the form.
I'll just search that, my lord.
Just search.
Yes. That, my lord, model charge, my lord, as per, my lord, this one justice. যে কিতাব নাম আছিল এখানে? Justice Castigar's Criminal Measure Acts, my lord.
Okay.
Their model form of charge of 302, my lord.
CRPC condition.
That you on or about so and so day and so at place so and so did commit murder by intentionally or knowingly causing the death, name of the deceased, and that you thereby committed an offense punishable under section 302 of the Indian Penal Code and within the cognizance of this court. Accused should know, my lord, that they have.
Yes, that is settled. That
Yes,
you should know what is the exact search.
My lord. Here, my lord, at page 45, your lordship will find.
Yes.
At page 45, my lord. Here, my lord.
Okay. Just a minute.
এখন তো পারলো বলেন না ইয়েছে সরকারও আছে নাকি
Just a minute, give a minute.
No, with your lordship permission, my lord.
Yes, yes.
The new record that has come. my lord.
Yes, yes. What new record?
The statement of two witnesses and the FSL report has been called for, my lord.
Okay. Anyway, yes.
My lord, here in this page 45, Lordship will find that on 17/8/2011 at about 3 p.m. at Assam University, under so and so, you in this 4%, my lord, you in furtherance of your common intention, inflicted injury on the person of deceased name, my lord, as a result of which the deceased died after about 1 month due to septicemia at SMCH. This is important, my lord. You would be responsible for causing death of the deceased. He would be responsible for causing death of the deceased if the above facts are proved and thereby committed an offense punishable under section 302(34) of the IPC.
Yes.
So while framing charge, my lord, on the day of framing charge,
Court is, according to you, court itself is not
he is not sure,
confident,
my lord,
not
whether
sure.
it is 302
Then
or
it
not.
says, it says that it would be responsible on ifs and
If the
buts.
facts are proved, my lord. When the trial will end, my lord, then it will be proved. What, my lord, my lord, always we find in our paper book, my lord, that you commit murder of so and so and so and so, my lord. So, my lord, that is one of my humble submission before your lordship, because charge sheet was not submitted under section 302. My lord, that order dated, my lord, 5/3/2016, which I annexed also, my lord. With that injury report, my lord. Here also, my lord, this 302 charge, I have perused the case record as well as the charge sheet. But in the, my lord, case record and charge sheet, there was no 302, my lord. I have annexed the charge sheet, my lord.
Charge sheet page,
my lord. Charge sheet kote, become the
Page 35.
Page 35. Page 35, my lord. Lordship will find at page 41, my lord. Third line.
page 41.
Page 41, my lord. Case, my lord, last line also, page 40, my lord, case was registered under section 143, 325, 379 and started investigation. Later section 302 was added after the death of the victim, my lord. During investigation of the case, sufficient evidence of guilt under section 147, 148, 149, 381, 323, 325 IPC has been established from the statement of witnesses against the name of the accused persons, my lord. The name of this 5 accused persons are there, my lord.
Yes.
Then, my lord, this order of my lord, learned CGM, my lord, on the basis of this search sheet, my lord, he has passed this order dated, my lord, 5/3/2016. Then, my lord, subsequently, that charge under one head, which I have just pointed out, my lord.
Under 226, the session judge will not be powerless to frame charge under
Yes,
302.
Yes, my
Even if in charge sheet 302 is not given.
lord.
But what about the cognizance of magistrate? Is it permissible
My lord,
that charge sheet is filed without a provision,
302.
sessions triable provision, without?
Yes.
Can the magistrate take cognizance of that charge?
If he finds that, my lord, there is material to frame charge, my lord.
No, framing of charge will come under 226 by the sessions court.
My lord.
What I'm saying is,
My
at
lord.
the stage of cognizance by magistrate,
Yes.
a charge sheet is given without 302.
Without.
Will the magistrate have the power
My lord.
to take cognizance under 302?
Yes.
It will, but
care.
there must be something to express.
It is there one provision I have once read, Lordship, that he can go through the records, and if he finds that this is a sessions tribal case, he can take cognizance and commit the case to sessions.
Okay, that is fine.
That is
but-
what he has done here.
Huh?
That is what he has done here, my lord.
Okay, other offenses are not sessions tribal,
Other offenses are
not sessions tribal.
Only 302 is sessions
302
tribal.
says so. He has
So
taken.
according to him, my lord, after going through the record, my lord, that is, my lord, that sheet of paper and the statement of my lord, Sebika Malakar, she has come to a finding that there is a case of 302. He has taken cognizance, my lord.
What the note says, even if we take it to be correct,
My lord.
it says that these are the person who inflicted the injury.
That is not there. That is missing. What she has stated, my lord, this is, my lord, he only wrote the name in the piece of paper.
Okay, fine. We say that her statement is also correct.
Yes, yes.
At this stage, we will not say that
Yes,
her statement is also correct or not correct. That is a subject to trial. Subject to trial. So we take it her statement to be correct, that she named her nephew named these persons to be the who assaulted them along with Amit or all these people.
Yes, yes.
Even if that is correct, your argument, what I could understand
lord,
is that even if that is correct, where is the case of 302?
Where is the?
In view of this admitted position.
Yes, my lord.
This is
Where are those injuries, my lord? He received only one injury. That too also, my lord, a cut injury here and one abrasion in the left, my lord. And my lord, post-mortem report.
Suppose another aspect of the myth. Suppose it is septicemia.
My lord.
And it is established in the trial that it is a septicemia arose out of the, assuming for a moment, the injury inflicted in the eye. Then will it be a 302? That is one aspect. And can we decide at this stage that whether it will be 302 or 30 part 1 or 304 part 1 or part? Okay, anyway, yes, next.
But the only thing, my lord,
that period and this admitted position, a reason according to you, there cannot be any suspicion of 302 because we are on stage of suspicion, not prima facie case.
Yes, man.
There cannot be any suspicion on the basis of this material that this is a murder.
It is a murder.
This is clear, crystal clear that this cannot be a murder because we are at a 227 stage. Yes.
And my lord, at this stage, my lord, we have to look at the post-mortem report also, my lord.
Post-mortem report, yes.
Because, my lord, from the post-mortem report, my lord, that septicemia could not be connected with any of the injuries, my lord. Normally, my lord, I have searched some of the my lord decision where death has occurred due to septicemia. In those my lord decisions, I have seen my lord that
Now
septicemia
here, according to you, septicemia is not
because of
relative.
the
There is
not
no
relatable injury.
no method that septicemia is, in the opinion of the doctor, which we assume to be correct as a that is not relatable to the
Is
injury
related to the
inflicted,
injury.
because by that time injury was healed by the injury report itself, and that by the doctor and the statement of the prime witness, the father.
Yes.
This is your case.
Yes, ma'am.
So we'll take it to be correct. So therefore, on the basis of this, there should not be any suspicion that this cause of death is arose out of 30
Because of the
out of the injury.
Yes. Injuries.
Yes.
Hmm.
Yes.
My lord, in form number 32, my lord, schedule charges, my lord.
Okay. I think that there is a form number.
Form number 32, lordship will find.
Schedule.
Schedule 2.
Schedule 2.
Schedule 2, my lord, form number 32.
See.
Lordship will find on section 302 and 304, my lord.
Schedule 2, no?
Yes, my lord.
Schedule 2, form number.
Form number 32, my lord.
2 or more heads.
Charges with 2 or more heads. Then, my lord, number 2 on section 302 and 304. This is to be informed to the.
So it's a statutory prescription.
Yes. That, my lord, court has to, my lord, tell them that, my lord, you have committed murder, my lord. That you honor about so and so, of so and so, committed murder by causing the death of so and thereby committed an offense punishable under section 302 of the Indian Penal Code and within the cognizance of the Court of Session.
Okay. Okay.
Yes, which one? Now coming to, my lord, septicemia.
Okay.
I have, my lord, consulted some, my lord, doctors, my lord, and from that, my lord, from them, my lord, I could able to get some, my lord, from some
It's an infection
journals.
of blood.
Poisoning of
Cause may
blood.
be poisoning of blood, cause may, and it leads to multiple organ failure.
Yes.
And it's a various serious kind. This can be, as we know from our septic.
Septic.
That is from injury, or it can be from any disease.
Any disease. That
Any
is,
disease.
I am on that, my lord.
Any disease.
Any disease. For that, my lord, I have got this paper.
Injury because
This can be from injury, or this can be from internal also. He was having for last 5 days fever with rashes.
Yes.
That is the indication of
The
sepsis.
indication of that. That, my lord, those things, my lord.
But that we will have to satisfy next, that to what extent we can go in this stage. That is having belief and passing an order in exercise of power are two different things.
My lord, without going through this, my lord, whatever I have submitted earlier, my lord, by that only, my lord, my humble submission before your lordship, my lord.
Because there may be suspicion, again the suspicion, septicemia, whether it started with the injury, original injury.
That is missing in the postmortem report, my lord.
Postmortem report.
Because we have to go by that postmortem report only. New facts cannot come in the trial, my lord. From whatever, my lord, materials the IO
Now
has.
let us,
my lord.
But
Our, my lord, general thinking is that, my lord, when a person is hospitalized, my lord, he usually gets, my lord, this septicemia. That is general, my lord, thinking, my lord. Here, my lord, this septicemia is more common in people who are hospitalized. or have other medical conditions. Then my lord, definition of my lord septicemia, as your lordship has just stated, my lord.
Because I am stated to be a victim of septicemia.
My lord.
But now it is also doubted whether it was correct or not.
Septicemia or not.
Not.
My lord, septicemia, sometimes called blood poisoning, is an infection that occurs when germs get into the bloodstream and spread. The germs are usually bacteria, but it can also be viruses or fungi. Then, my lord, who might get blood poisoning, my lord? Anyone can get septicemia, but it is more common in people who are in the hospital or have had recent surgery, especially those who have catheters or IVs, have infection or other chronic medical conditions, for example, diabetes or cancer, have severe injuries such as extensive burns or open wounds, have weak immune system. A person having weak immune system may also, my lord, attack with septicemia, my lord. Then, my lord, what germs can cause septicemia? Almost any type of germ can cause septicemia. The ones most often responsible are bacteria, including, here are three, my lord, Streptococcus and Streptococcus pneumonia, and my lord, E. coli. And how does, my lord, the septicemia affect the body? Septicemia can lead to sepsis, which is a life-threatening medical emergency. It can cause tissue damage, organ failure, or even death. Then, my lord, what are the symptoms and causes of, my lord, septicemia? What causes septicemia? Bacteria, viruses, and fungi can enter the bloodstream in many ways. For example, abscess tooth, germs on medical equipment such as surgical tools or needles, kidney infection.
Even in saline.
Even in saline,
Saline.
that IV fluid, it is,
Yes.
it is stated, my lord. Then, my lord, kidney infection, pneumonia, then, my lord, skin ulcer or other wounds, urinary tract infection. Then, my lord, because of septicemia, my lord, high fever will be there, chills will be there, weakness will be there, sweating will be there, and there will be drop in blood pressure. And this can cause death, my lord. May I give this, my lord? In another writing, my lord, it is there, my lord. These are almost common, my lord. While sepsis often occurs in hospital settings, it can also happen in other location. In some cases, you might not even know you have an infection that could potentially lead to sepsis. So without, my lord, knowing also, there may be, my lord, septicemia, my lord. Here also, my lord, any infection can trigger sepsis, but the following types of infections have a higher risk of causing sepsis: pneumonia, abdominal infections, kidney infection, blood poisoning. It can be divided. यहाँ ना लगे नहीं कुछ जो
I have done this research while inside hospital, struggling with sepsis.
This lordship might have read all these things.
Yes, yes, because I did not have any job to do
My lord.
except reading this. But all the symptoms were there.
My lord.
Blood pressure fell up to almost nil.
50, 60 or less than that.
Yes, maybe more, less. Then some infusion here. But in my case, it was time space is so little, now everybody doubts that this cannot be a sepsis because sepsis will not go like this.
My lord.
Anyway, that chapter is over.
Another paper, my lord, on the same line, my lord.
That we may not go also. We are basically on the, we'll see sepsis is sepsis.
My lord.
Now, yes.
This is my, basically, this is my submission, my lord. I have just make a note, my lord, how this whole thing has happened.
Yes.
With this, my lord, I conclude my argument, my lord, my humble submission, my lord, before your lordship, that this is not a fit case for framing charge, not under section 302/34 or any other sections. This is my humble submission before your lordship.
Okay. Yes, who will argue now? We better, yes.
Yes, that part, my lord, the last occasion, my lord, two witnesses were called for. My lord.
Just a minute.
Yes.
These are the statements of.
Yes, they are also the injured witnesses, but it was not there at the earlier point of time. So now they
Everybody
are
name Amit.
and they stated that they were
They will be able to
they
identify.
were also assaulted.
Huh.
The second
And
part
they will
that
be
is
able
there,
to identify.
and they will be able to identify
Identify.
after that. These two statements, my lord, are similar, my lord. And my lord, and again regarding FSL part also, my lord, some authenticity has been brought by the FSL report, my lord, that has come, my lord. So now, my lord, we cannot say that it is merely a piece of paper, my lord, because because some authenticity has been, my lord, laid down by the FSL expert that the handwriting matches, my lord. That is what now came out, my lord. Now going to the stage of this case, my lord. Now, my lord, we are here for, my lord, regarding whether at the stage of framing of charge, my lord. And your lordships is aware, my lord, for that at
If
this
there
stage,
is,
my lord,
if there
at
is
this-
even
at-
suspicion,
grave,
then
it appears to the learned trial court that is, if there is grave suspicion there, that the trial could be proceeded, then he can proceed with the trial by framing the charge, my lord.
he
And
is
if-
proposing
Yes.
one thing, that if you accept everything to be correct,
No.
everything correct, from date of incident, saying I can identify these people at the document, verifying that these people are, there is a suspicion that these people are present in the
Yes,
situation.
yes.
That is
So,
clear now.
That is clear, my lord.
There is a suspicion, grave
There is a
suspicion that this
suspicion
person
because
will be
of
there
the
because
corroboration is there, my lord.
of the foreign this
Only
report,
corroboration.
and there is a suspicion.
Yes.
Now, his case is that, okay, there is a suspicion, but
Yes.
how can you charge me under 302? Because on the material available on road, there cannot be any suspicion, grave suspicion as regards proximity between the date and the cause of death to be the assault.
Yes.
This is, I think, the limited position as on right now.
Yes, only the framing of the regarding the
302.
302, my lord.
Others,
Yes.
okay, fine,
Yes,
302.
my lord. Now, my lord, in a trial, my lord, what happened, my lord? If my charge is framed under a lesser section which carries lesser punishment, my lord, we do not know, my lord. There's, my trial could, my lord,
No, you
result-
do not know. Suppose we frame 302, it's you cannot convict under 302. But if
Yes.
it is done 302,
Yes.
then you can give a lesser
at the point of trial,
lesser-
if it has, my-
lesser-
if it has
lesser
come-
punishment.
Yes, yes. If it is-
But will that mean
Yes.
that when there is, can the frame charge be framed like this?
That will be, my lord, from the satisfaction of the, my lord, from the record, my lord, from the satisfaction
So
of what.
the learned
Yes.
trial
Yes.
court ought to have said that
Yes.
for this reason, you are charged with 302.
Yes.
Simple.
Yes.
But it says,
Yes.
why this suspicion in mind in the courts?
Yes.
That we need to get explained.
Yes.
Court says that if there would be any evidence, you will be. That is
Yes,
always.
that is in all
But
cases.
this is charge against you, that
Yes.
you have committed this.
Yes.
Here, we do not know whether you have committed
Yes.
or not, but you will be punished. That is always there.
Yes, that is what, my lord, perhaps in the mind of
No,
the.
therefore, perhaps the mind of the learned judge was also this, whether I can link with this
Yes.
cause and the date,
Yes.
the proximity. He was also in doubt.
Yes, because, well, if
Now,
he-
what you say on this point?
And that
Forget
is what-
about the learned judge.
Yes, and that
Some
is-
technicals here and
Yes.
there, we may not interfere
Yes,
at the
because
stage
that
of
is the-
here.
at this stage, and they can all
But
very well,
this argument we will have to address.
very well, my lord. they
Rest
will-
are fine. This
Yes.
argument we will have to address.
Very well, my lord, they could come up for, there is, because there is always the provision for altering the charge, my lord. That is one option is always there, my lord. And had it been.
Just a minute.
Yes. Hmm?
According to you, shall not prejudice. Okay? So it will not prejudice him because
Yes.
for the reason that
Yes.
otherwise there is a grave suspicion for 304.
304.
Uh.
Now, my lord, suppose it case of at the end of the fag end of the trial, my lord, if it has been found that no, my lord, they can be convicted under 302.
So when there is no proximity, therefore 304 will also not come, according to them.
Yes, according to them, my lord. But that will depend upon the, my lord, consequence of the trial, my lord. Because, my lord, at this stage, if, my lord, a lesser section, perhaps, my lord, if it is, my lord, charged under 325, like, for any hard, my lord. So, my lord, then the
Your
trial
case is that
cannot
a
be-
determination cannot be made
Yes.
on the basis of material available in record
Yes.
that there is no proximity between the cause of death
Yes.
and the date.
Yes.
Injury and the date.
Yes.
In as much as there is a suspicion that this is the cause.
Yes, there is a.
So therefore,
yes,
rightly framed the search.
rightly framed search, and also my lord may see the first medical report. There the injury is grievous, my lord. There the injury is grievous, and even in the 326, my lord, it carries now a punishment for life, my lord. So now a session tribal, my lord. Now also, my lord, 302, it has been, my lord, charged because from the witnesses so far examined, my lord, it is clearly, very much clear from the statement that it's corroborating that they are the person who have assaulted, and on that day, these three witnesses are there, my lord. So from this, my lord, revelation, my lord, frame the charge under section 302, my lord. And it is not that if my lord, now at the beginning of the trial, in the course of the trial, if they could not be 302, they might 304 part 1 or part 2. That is a different thing, my lord. That we cannot, at this stage, we cannot decide, because the, my lord, principle here is that it is not, my lord, essential, my lord,
Yes.
to say, my lord, whether conviction will sustain or not, my lord.
Yes.
That is, my lord, the main thing is that, my lord, it is not at this stage, we
You
cannot.
can say no prima facie case is required here.
Yeah,
What
no,
is required is a suspicion.
only suspicion. Like
Grave
it may
suspicion.
lead to conviction, it may not, my lord. So whether that is, so, my lord, after going through the record, my lord, the grave suspicion arose, my lord, regarding their involvement with the case, my lord. So
Your case is that injury was grievous,
yes,
continuous illness,
a continuous illness,
resulting in death. And possibility is there that septicemia may be there, which
Yes.
will be revealed during trial
yes,
only.
yes. Now, my lord, just I am rely on, my lord, just one judgment, that is a very famous judgment, Lordship. That is the Sajjan Kumar case, my lord, in the 1984 riots, my lord. There also, my lord,
Sajjan Kumar
suspicion-
citation was?
yes, my lord, is 2010, my lord, I am giving, my lord.
Okay, I think so you proceed your argument.
Yes, ma'am. I'm giving the ma'am. 2010 9 SCC 368.
2010
9 SCC 368.
368.
Why I'm drawing my lord inference from this case? There are other cases also, my lord. Why I'm drawing, my lord? Because here also, my lord, the charges are framed after a gap of 25 years. My lord. And only on the basis of some statements where, my lord, no eyewitness are there. On that case, there is no eyewitness, my lord. Only of my lord, statement of some witnesses who said that he is involved. He will, because only on the basis of, and that create a suspicion as per the, my lord,
Involvement of this
yeah,
person.
as per the principles laid down, my lord, that is enough, my lord, to frame charges against the Sajjan Kumar at that point of time, my lord. So now also, my lord, this decision is relying on, and in several other decisions also, this judgment has relied on, my lord. And this is also, my lord, one fact has also been, my lord, cleared there, my lord, that whether the proceeding of the trial would result in the prejudice of the accused or the, my lord, victim, my lord. That has the balance has to be there. So, my lord, who will be, my lord, prejudice, my lord, by not proceeding to the trial, my lord? That is also specifically, my lord, is there, my lord. So this is the, my lord, what the law says at this point of time, my lord. And others is that, my lord, regarding and another decision, my lord, just now Steve may kindly just I have taken out print out just now after one. That is 2023 Live Law SC 494.
Justice, my lord, Justice Pardiola's judgment.
No, Supriya Jain versus State of Haryana and Andhra, my lord.
Oh, you authored by?
Authored by, yes, my lord. Yes, Dipankar, Dr.
And oh, yes, that. Yes.
That judgment, my
That I
lord.
am having it.
I have also given it on the mail, my lord.
Okay.
And
already have
yes,
print out
my
at the morning.
here, my lord, just I want to rely on one 17, my lord, paragraph 17, my lord, just I am reading, my lord. This is a case where the charges have been framed and the accused
Para
are
17.
17, my lord. This is a case where the charges have been framed and the accused are awaiting trial. Having regard to the totality of the facts and circumstances, notice above, we are of the considered opinion that the investigation and the follow-up steps are not so patently unobtrusively defective or erroneous, except to the extent we propose to mention before concluding our judgment, and allowing the trial to progress might cause a miscarriage of justice. This is also not an appropriate stage to delve deep into the records. It is no part of the business of any of the courts to ascertain what the outcome of the trial could be, conviction or acquittal of the accused. Just now, man, I have negative. The small window that the law through judicial precedence provides is to look at the allegations in FIR and the materials collected in the course of investigation without rebuttal thereof by the accused, and to form an opinion upon consideration thereof that an offense is indeed not disclosed from it. Unless the prosecution is shown to be illegitimate so as to result in abuse of process of law, it should not be proper to scuttle it, my lord. That is, my lord, whether it will cause to abuse of process of law unless and until it is there. In that case, only, my lord, 482 can be, my lord, exercised by this court, my lord. And lordship can see that is reflected in page 17. And also, my lord, here the principles.
Paragraph 17.
Yes, my lord. There, my lord, principles guidelining, my lord, this in the Amit Kumar versus Ramesh Chandra's case has been laid down, my lord, in 27. My lord.
Okay.
A grave suspicion, my lord. Also, my lord, I am submitting from the record that my lord, the last piece of evidence that is was, my lord, seized, my lord. That the piece of paper where he have given is the names of this accused person. That is a very vital aspect as per my lord humble submission, because at the before that is can be taken as a dying declaration also, my lord, because that's the piece of paper he has written the names of those persons at least before, because at that point in time he might not have identified. And at one question will come, my lord, whether why parade is not done, my lord, identification parade. Because, my lord, they were not available at that point of time in the stage of investigation, my lord. They are just absent at that point of time. So, my lord, so parade is, my lord, not done. And now, my lord, after that, man, he has written those names, and the after seizing my FSL report has, my lord, authenticated that yes, this is, my lord, the same thing, my lord. So it's a very vital piece of, my lord, evidence, my lord, at this point of time to, my lord, at least which create grave suspicion in the mind of the court, my lord, court and the trial, my lord, this lawsuits and the trial court, that yes, my lord, they can be proceeded with the trial, my lord. That is what from that, my lord, evidence, my lord. Whether that will lead to conviction, my lord, other things will come on later on, my lord. So I am relying on that judgment, my lord. 27.1 wine, 27.2, 27.3, and everything, my lord. The lordship will kindly explains, my lord. And another, just, my lord, I have just this High Court, my lord, relying on, my lord, in my lord, Hare Krishna Medhi versus CBI, my lord. This was a judgment delivered by our retired Justice H.N. Sharma, sir. He has also relied on this Amit Kumar's case and also, my lord, Sajjan Kumar's case, taking the principles from there. Yes. And just, my lord, I have tick mark.
Paragraph?
Just I have, my lord, a tick mark, my lord. Paragraph I have
Okay,
not written.
27.
Yes, my lord. Your lordship will find, my lord, from those, my lord, that where, my lord, to exercise the principles laid down, when, my lord, court should restrain, or when the court should exercise the power that is given under 482, my lord, at the stage of, my lord, charge, my lord.
Okay.
Yes, ma'am. Now, my lord, injury part, my lord, I have just, my lord, pointed out, my lord, grievous, my lord. So that your lordship has pointed out, man. And regarding the death, my lord, whether septicemia could lead to death, I have also, my lord, searched for, and the lordship also made a, my lord.
That is not so likely.
My lord, the cut injury, my lord, that was, my lord, that can also lead to septicemia, my lord. That is also there, my lord, because now the how death is caused, death is due to cardiovascular failure following septicemia, my lord. And how septicemia is caused, my lord? That from the case record, it could be very much established that that from the cut injury, grievous injury that was inflicted upon his eye by this accused persons, my lord.
Okay.
So, my lord, at this stage, my lord, lordship may not like to interfere, my lord. Let the trial be proceeded, my lord. So that, my lord, at this stage, my lord, balance is. So considering the balance, my lord, the prejudice will be caused to the, my lord, victims, my lord, family, my lord, if the trial is not proceeded, my lord, and the charge is not
Yes, now
taken.
victim's family.
Sure.
Already my learned friend has placed everything, lordship, that I am not repeating those facts. Just only one thing, lordship, may kindly see page 61 of their petition, lordship.
Page 61,
61.
just a minute.
This is the restatement of the father, lordship.
Page 61. Yes.
Here your lordship will find that the details have been given. First, initially he was taken to Silchar Medical College. Then, because of he had to take he has to take to Guwahati, lordship, bring to Guwahati, and they need some money, so they went to Korimganj. That reasons are there. That your lordship, we needed some money if we have to go to Guwahati for better treatment. It is not that he has recovered and therefore he went to Korimganj. We went back to our house at Korimganj at around 7 p.m. That day, that is 19/8/2011, in order to manage some money. Then, after managing some money on 21/8/2011, Ratnadeep was taken to an eye specialist, doctor of Guwahati Shankardev Netralaya, who happens to sit at a pharmacy in Karimganj town. But but he also advised the same. Therefore, on 22/8/2021, I took my son to Guwahati in night super bus, and on 23/8/2011, we went to consult Dr. Harsha Bhattacharya of Shankardev Netralaya. After treating and examining him on 23/8/2011 to 30/8/2011, when Ratnadeep's eyesight got a little better, he has not completely recovered, a little better. The said doctor asked us to come after 21 days for checkup. So further checkup was there. It is not that he has recovered, so he was released. It is not that case. And in between losses, thereafter on 12/9/2011, Ratnadeep felt unwell and started feeling severe pain in his abdomen. And now just one more thing I'm pointing out. Page 41, your lordship may kindly see. 41. Page 41. This is the part of chart sheet. Last line, your lordship may kindly see medical report of injured 4 numbers. The postmortem was done admittedly after 1 month. So whether there was any physical injury or not, that can be ascertained from those medical reports, Lord. Probably those
Page 41, what you said?
last line. Last 4 lines, also a sketch map of place of occurrence with brief description, 2 numbers of seizure memo, bail bond, 1 numbers, postmortem report, 1 numbers, medical report of injured 4 numbers. FSL report, number 1, etc. are enclosed. So whether initially he sustained any injury or not, that can be ascertained from those medical reports, lordship, not from the postmortem report. And whether these have any proximity or not with the death, lordship, that can be ascertained after examination of the doctor, because this is an expert opinion and that can be rebutted at the time of trial only. And other judgment which I have already placed before your lordship, that I am not repeating, just I'm saying the names, lordship.
Just give the citation.
I am giving that 2 copies, Lordship.
Yes, that he has already.
That's good. And that's page 75, that your Lordship has already seen that 3 witnesses came up as a injured witness. And at least their evidence may be recorded to identify, because at the time of investigation, as my learned friend has already pointed out, that they were absconding. And if the case proceeded under section 302, Lordship, that no prejudice will cause to the accused side, Lordship, that. Because they are already on bail and they can cross-examine the witnesses. in trial.
Okay.
Of like,
Just to reply, my lord.
Yes.
302 charge, my lord, whatever material is there, my lord, as on today. With that only, my lord, 302 charge can be framed. Not that in future some evidence will come. And by that, my lord, 302 can be added, my lord. If some evidence come, my lord, then 302 can be added. But why today, my lord, charge under section 302 should be IPC should be framed, my lord. Whatever, my lord, material is there before the court as on today, my lord. My humble submission before your lordship, my lord, there is no material to frame charge under section 302 IPC. And for that reason only also, my lord, the trial judge also, my lord, he was not satisfied, my lord. So, my lord, as my lord learned friend has my lord submitted, that let there be charge of 302. If that is not proved, my lord, for lesser offense, you will be, my lord, convicted.
Your case is if
That
no
is what-
material, why should I face a trial? under
Why I
302?
should face the trial of
This is-
302 before a my lord session court. And my lord, the injury report, 4 injury report, my lord.
Of 4
those
persons.
4 persons, my lord. And
One is his and the other.
other
of
3 injured
three
persons.
injured persons.
And my lord, the injury report is already before the court. What injury has sustained, my lord? 2 injuries on the eye, my lord. And that injuries, my lord, that has not been reflected in the postmortem report, my lord.
Yes. Heard Mr. BM.
just one thing, that page 45, just one more time.
Yes,
Page
45.
45. Object to correction, so what I have found, Lordship, what I have understood, that facts are already there. It is not that facts will come, Lordship, just may I read?
Yes.
Firstly, that on 17/8/2011 at about 3 p.m. at Assam University under Silchar PS, you in furtherance of your common intention inflicted injury on the person of Ratnadeep Malakar. So it is already this fact is there. Since disease, as a result of which the deceased died after 1 month due to septicemia at SMCH.
See, I tell you one thing. Okay, you are correct on in that sense.
And
Why he is saying doubt is this could have ended here as a result of which the deceased died. Full stop.
Yes, that I understand.
No further thing is needed. After about
that
1
full-
month.
full stop is there.
After about 1 month due to septicemia. We are not saying that
These
this
are the
should be
facts.
this should be fatal if their materials are available. If suspicion is there, this will not be fatal to set aside. That we understand. But we are thinking over it.
My lord, on the last occasion, I have given a my lord number of decisions.
That is there. This is.
Decisions are there, my lord.
Mm.
There has to be prima facie case has to be there, my lord.
Mm.
2019 9 SCC 148, my lord, para 9.
Yes.
It is the duty of the court to apply its judicial mind to the material placed before it and to come to a clear conclusion that a prima facie case has been made out against the accused. An order for framing of charges is of serious concern to the accused as it affects his liberty substantially. Court must therefore be cautious that their decision at this stage causes no irreparable harm to the accused.
Yes.
Then, my lord, the
10.
2010 SCC, my lord, Bijan's case, my lord. Here also, my lord, if two views are possible, and one of them gives rise to suspicion only, as distinguished from grave suspicion, then trial judge will be empowered to discharge the accused. Then, my lord, the trial judge is not a mere post office to frame the
That is well
charge.
settled. That's
These are, my lord, settled law, my
settled
lord.
law.
My lord, there has to be a prima facie case has to be there, man.
Of course.
In almost
Manner standard may be different at
Yes.
this stage.
But in almost all these decisions, my lord, that prima facie case should be there, my lord. And it is, my lord, known that there should not be mini trial.
Ah.
These are also in this
Yes.
decision, it is there, my lord.
Third, Mr. B.M. Chaudhary, learned counsel for the,
My lord.
uh,
Just to,
Yes.
regarding the materials, my lord, that regarding 302, my lord. Lordship, may kindly see the what FSL, my lord, report is, my lord. Because there, my lord, he has written their names, my lord. So if we consider it as the dying declaration, my lord, there is specifically, my lord, the materials are there.
when,
again,
according to
proceeding
you,
again-
when common intention are there
Yeah,
and person has died, and if the cause of death is the injury inflicted,
injuries.
then individual role of these persons, whether omit had given the fatal blow or not, will not be
Because
uh,
from that day,
necessary.
my lord, he was hospitalized, and after that.
necessary.
on
And
the
his
basis-
case is that, okay, these are principle
Yes.
settled, but what is the material to say that even to raise a suspicion that these are the cause of death? That's all.
Yes.
Okay. Hard.
Witnesses, my lord, they have not stated that so and so is assaulted by this. That has not been, that cannot be improved in the trial, my lord.
Heard Mr. B.M. Chaudhary, learned counsel for the petitioner. Mr. Goswami, MP Goswami, learned additional public prosecutor for the state. And Mr. A. Ahmed, learned counsel for the informant, respondent number 2. Respondent number 2. Hearing concluded, judgment reserved.
Oblige. Oblige, Lordship.
Yes.
Lordship, this matter, your lordship, relates to framing of charge, your lordship, without having sanction, your lordship. Charge was framed under section 10, 13, and 18, your lordship, of the Unlawful Activities Prevention Act. And before your lordship, framing of charge and.
Now what to do today? 10 minutes, it will not be over.
No.
And I have a division bench at 2. And if we come back, we'll hear it.
Otherwise, your lordship, Friday, your lordship.
Right.
I will not take much time, your lordship.
No, your argument is simple.
Lordship.
Sanction is a mandate. He will say that yes, no sanction was there, sanction was subsequently taken, and this will not be fatal to the prosecution.
And my.
And he will argue that 456 CRPC, 456.
465.
465 CRPC shall be applicable. Now you will argue that
Why
if it-
465 will not come in this case?
why is 466? This is the limited 465 will not come in this case. And you will say that there is a difference between procedural lapse and no sanction, two different and distinct, isn't it?
Your lordship,
Lordship has already argued for both the sides.
We must ready with what should be the argument.
Correct.
Otherwise, anyway, when Today give a chance,
Tues-
because we
Tues-
have,
Tues-
if
Tues-
possible, we'll give.
Thursday no, no. Division of
কেতিয়াবা উঠে?
Let,
We do not know about the division bench.
can we try on Thursday, no? Day after tomorrow?
Thursday, holiday.
Huh?
Holiday.
Oh, holiday.
Thursday
That-
holiday.
Tuesday.
Friday.
Friday, yes.
Friday, how many meters?
We'll try.
Monday or Tuesday?
Tuesday, your lords.
Tuesday,
Tuesday or Thursday, or 30th.
30th. Okay, as agreed to by the learned counsel for the parties, list this matter on 30th, huh? 30th. What about if there is a bail that has been?
No, your lords, bail is by another bench. Your lords.
Okay.
One person was granted bail, your lords.
But there is some recent judgment also as regards bail that not granting of sanction and the default period.
Lordship, we are not praying for default, your lords, in that. That is Justice Bella Trivedi, your lords.
No, by my Lord Justice Chandrasur, Chief Justice.
One judgment by Bella
As
Trivedi.
regards the issue, whether the time period
Lords.
for filing a charge sheet also is relatable to 180 days, isn't it?
Lords.
180 days. Sanction. That may, I have not gone to detail. So far relating to sanction, it says that it is not mandatory that it should be within 180 days.
Honorable
it
Justice
can go-
Pardiyala, your lords.
I think so.
Honorable Justice.
It may go beyond. So it may go beyond. What can be implications if sanction is taken post cognizance? Anything will be anything relevant in that judgment?
No, your lords.
No?
That is related to
To
bail.
bail.
your lords.
That we understand.
Default-
That is
default
related to bail. Default bail.
Default
It says just
If sanction is not there, one cannot claim default.
claim
bail.
default bail.
Yes,
That is the principle.
that is the-
But in that case, there are certain observation, I think, which says that two different things. Sanction is not necessarily to be at within a specific date, 180 days.
It is there, your lordship, but there is one point is there in that judgment that cognizance cannot be taken without sanction.
Is that
Yes,
is
one line is there. your lordship.
Okay.
Depends on the materials placed before by the investigating.
Okay,
authority
we'll
for the
hear it.
authority.
What is this IA?
IA is, your lordship, already disposed of probably, your lordship. IA was for implement of the central government. your
Okay.
lordship.
Central government is there. Okay, on Tuesday.
Lordship.
Yes, sir.
This matter, instruction was sought. Government advocates for time for taking instruction.
Otherwise, matter, all these matters are, I do not know, my view is that all are infructuous.
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 Is not it? 107, how many days?
Your lordship may kindly peruse, I have trademark, in the first case, LCR. Those were, because, in view of, forthcoming parliamentary elections, at that point of time. But, now parliamentary election already.
What is this? This is page 15.
No, LCR.
LCR, give.
First case, LCR. Item number 24, I have flag mark.
You have not executed the bond.
No.
No, period is over, we'll close it.
Close it. Lordship.
Hard.
Observability.
We'll close it. All these petitions, separate orders, separate orders.
Separate.
Heard Mr. M.K. Hussain, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned counsel, additional public prosecutor appearing for the respondent number 1. None appears for the respondent number 2, 3, and 4. The present application under section 482 of the Code of Criminal Procedure 1973 has been filed by the petitioner, namely DD Boha, protected available. Assailing impugn notice dated 28/3/2024 in all cases.
Some 29, some 20.
Give the dates.
MR number and I'm giving the
Give
list.
the names where, impugn notice dated 28/3/2024 / 29/3/2024. Give the details of this to Hakim.
And MR
So,
number is different.
Issued by the respondent number 3 in MR case number dash. You give this case number under section 107 of the Code of Criminal Procedure 1973. The basic salience of the said notice is that the petitioner has received the impugn notice issued by the respondent number 3. However, while issuing such notice, the mandate of section 107 of the Code of Criminal Procedure 1973 has not been followed in as much as in terms of the afforded section under section 107, an order in writing setting out the substance of information received, the amount of bond to be executed in terms and the duration for which it is to be enforced, and the number, character and class of sureties, if required, are to be recorded in writing. What? Recorded in writing. Full stop. However, in this case, nothing has been done regarding compliance of the aforesaid provision. Full stop. Accordingly, this court called for the record, scanned copies of the record of the connected MR case. Full stop. From the perusal of the record, it is seen that the impugn that by an order was passed on 6/4/2024, which reflects that the said order was passed apprehending possibility of serious breach of public peace and tranquility during the election, and to election. Full stop. Election. Thus, from the aforesaid, it is seen that the apprehension was as regards apprehension was during the conduct of election. Full stop. The election is already over. Full stop. Now, the order further reflects that the bond was to be executed to maintain peace and tranquility for conduct of the election in the locality. Full stop. Thus the bond is also mentioned, and the region and period is also mentioned. Full stop. However, the election is already over, and therefore nothing survives to be adjudicated in this present writ petition. Full stop. Accordingly, the present application stands closed, being infructuous. The petitioner shall be at liberty to approach this court if necessity arises, if cause of action arises in future.
One word, Lordship. This order was passed subsequently serving the notice, Lordship.
Anyway, whatsoever, there was an order, let us not go to it. Election is over. Yes. Okay.
24 to 34, same.
All 34. All disposed. But you give the numbers, otherwise orders will not be uploaded. Yes, anything more? Okay. Yes, Mr.
One hearing item, 35, 36, 37.
35, 36.
2000 appeal of 2009. Can it be next week, madam?
Okay, okay, we'll pass this order. Let us see if we come back, then we'll take note of your prayer, or otherwise just take write it. Otherwise, I'll dictate the order if I come back, or otherwise 35 and
35, 36, 37.
These are 2009 matters.
Analogous, my lord, arising out of the same judgment.
One is acquittal, one is acquittal appeal. State and private respondent acquittal.
My lord.
And you are against conviction.
Conviction.
But 2009, it is a scar on us.
Yes.
Let us see in the second half. if we come back, otherwise,
Next week, my lord.
next week, we have dismissed all this petition. What is that provision? That it should be a decree. I have passed an order in one of your case. Where is
Order
that?
41, Rule 1, Sub Rule 3.
Let's just write it down. Order 41,
Rule 1,
Rule 1,
Sub Rule 3.
Sub Rule 3. And how it, we pass, I passed an order in your case. Which
And
case?
It is a money decree that has been narrated in section 169, subsection 4.
169, subsection 4.
Lordship, I am here only to express my apology that I could not remain present.
No issue. I pass an order in your case. If you can give that order, then it will be easier for us.
Pinky Lahan, one case, Pinky Lahan.
Just you give the number so that we can, from that we can do the job.
Yes, Your Lordship, I will provide it.
Your Lordship, circular number
Hello.
39.
Huh?
39. I thought we fixed in
39.
yes. In
What
June
is
1st,
this?
Your Lordship.
I appear for respond number 2 here. ma'am.
What is this?
Criminal revision
revision
petition
Against?
against
Against order of framing of charges, Your Lordship.
I'm appearing for the opposite party. I was the sub-inspector of police who lodged the FIR, and I have filed an affidavit that it was only under instruction from my superior. Let it come up next week. madam.
Okay. On the prayer of the learned council for the parties, list this matter, not next week, thereafter. Give a date. Listed on 7th of June.
Obliged.
Anybody? Any other cases? So this is gone.
38 Lordship.
39 gone. 38, yes.
Lordship, matter may fix some other day, Lordship.
39, we are not adjourning right now. We will adjourn and fix a date if we don't come back.
Lordship, 38.
2009. That's why.
Not agree.